Morning, everybody. Sincere apologies for the delay starting up this morning. Welcome to this presentation on GDPR, data protection, and what you need to do in your small business. I'm Jo Brianti, and I'll be taking you through the presentation. The agenda for this morning is we're going to have a sort of very brief introduction, and I will keep it really brief. And then we're going to talk through the 10 key steps to achieve GDPR compliance. We're going to talk about principles, rights, roles, responsibilities within your business based on GDPR. We're going to talk about accountability and general governance. And then we're going to talk about some best practice and how data protection is increasingly important in the tendering and bid process. So this is me. I'm Jo Brianti. These are some of the organisations that I've worked for. I'm a CIP-E accredited data protection officer, and I've been working in data protection specifically since early 2017. Previous to that, large-scale business project transformation in global and national organisations. So there are several pieces of legislation that we need to think about when we're thinking about data protection. There's the UK GDPR, which forms part of the Data Protection Act 2018. There are the Privacy and Electronic Communications regulations. And also, if you are working with clients in the EU, you will have to consider EU GDPR. At the moment, there is very little difference, but obviously post-Brexit, that may change, so we have to keep an eye on that into the future. Also, if you are working on a global basis and you have clients or you're delivering services internationally, you now need to think about global data protection and that landscape. We now have 107 countries, and that is a growing number, who have or are developing privacy regulation, and a lot of them are based on GDPR. So it is really important as part of your sort of global operations to think about that, in addition to the other global regulations you may have to take notice of. So this is the 10-step process that I've devised that helps you achieve and maintain your compliance. The first 3 elements: map your business processes, undertake the audit, identify the legal basis for processing. They're all an integrated single task, or they can be. And undertaking a data audit is a mandatory GDPR requirement under Article 30. So, but there are many benefits which we'll talk about as we go through. Without those 3 elements in place, it is really difficult then for you to manage some of the other aspects of GDPR. So as part of GDPR, we need to think about how we're evaluating our suppliers. Do we need to conduct data protection impact assessments? What are we doing about data security? How are we protecting the data that we process? What happens if something goes wrong? What do we do about a data breach or a data incident? What's the difference? How do we manage those? And you can't manage those accurately unless you have done steps 1, 2, and certainly 3 as well, because you need to understand those to understand your data breach processes. Subject access request and the additional rights that people have that come off the back of that. So once they have access to their data, they can ask for additional information or actions to be taken. The next thing you need to understand is, how long am I supposed to keep this data? What is the legal requirement? And it's not just GDPR. There are other pieces of legislation that are involved in that process. And the final step is communication. As part of the transparency principle, we need to be communicating with staff, suppliers, our team, subcontractors, and anybody else who comes into contact with our business. I'm going to take a couple of steps back and just translate some of the sort of technical jargon that we have within GDPR. And the first one is, what is personal data? In short, it's any piece of information you hold that relates to a living individual. Typical examples: name, address, email, but equally, you need to think about description. So if you're referring to that old man that lives at number 15, if there's only one old man that lives at number 15, that can identify him, so you have to be careful. Andrew, do you think you could put yourself back on mute, please?
My wife is, today rain, tomorrow rain.
A telephone number on its own is not a piece of personal information. Let me just see if I can mute.
Weekend, I think. I'll speak to her tonight and see whether she can come down. But I'll give you a buzz. What's your phone number anyway? We'll try to get it from.
A telephone number on its own is not a piece of personal data because it doesn't specifically identify on its own. However, if you combine that with a name or an address or an email, it could be a personal identifier. In addition to the sort of basic personal data, there is something called sensitive personal data, and it's important to know and understand the difference, because sensitive personal data has additional requirements for management and protection. And these listed here: religious beliefs, sexual orientation, or information about somebody's sex life, health information, political opinions, criminal record, biometric, genetic, trade union membership. Those are the pretty standard ones. There may be others that are particular to different organizations. In terms of GDPR, processing is anything that you're doing to collect, to store, to amend, to move, to transfer, to share personal data. Photos, videos are also personal data. So you need to think about these scenarios about when you're talking about what processing you're doing. So the key principles of processing for your organization: when you process somebody's individual personal data, you must ensure that you're doing that lawfully, fairly, and you're doing it in a transparent manner. You're minimizing the purpose and limiting the purpose. So as an example, if you collect a piece of personal data in your business for a sales event, you cannot then use that piece of data in another context without ensuring you have the relevant consents, or the consent that was granted in the first place was granular enough to allow that additional purpose. You should ensure that you collect the absolute minimum data required in order to achieve your company objective and service either the contract or the needs of your client. You need to ensure that the data is kept accurate and up to date. So when you look at your CRM, how many people on your CRM have changed businesses and have a different email address, or perhaps they have a different home address or something like that? It's really important that you manage that properly. You need to ensure that you're keeping data for no longer than is absolutely necessary. So we need to think about what's the data retention period. Is there a legal obligation, or am I using a business requirement to drive that? Either is acceptable. We need to ensure that there is appropriate security for personal data. So you need to ensure that you're doing things like backup, and that you're doing malware checks. Who's got access to it? Where are you sharing it? How are you sharing it? And this one here, accountability, this is where you're required to show that you are achieving all of these things, that you didn't just do GDPR in 2018 and you've not done anything since. There needs to be a demonstration within your business of active management. And I know that sounds like an administrative overhead, but if you build this into your business processes, then you minimize the additional effort required. The legal basis for processing. So there are 6 listed legal bases for processing. Consent. Now this has to be explicit, specific, for the stated single purpose. And it can be granular. And there must always be the option for somebody to remove their consent for processing. To deliver a contract under terms of a contract or specific steps, or as part of the bid and tender process, you might be collating data for that purpose. Where you have a legal obligation, so excluding contract, we all have legal obligation to report personal data around, let's say, employees for PAYE, tax, national insurance, those kinds of things. Vital interest. So if you're an employer, you may have information in your HR system around somebody's health issue. For example, if somebody's diabetic and they have a diabetic episode at work, it would be important for you to inform the paramedic of that fact. And so therefore, under GDPR, you are allowed to share that personal data in order to have an impact and save their lives and protect their life. Public task. This is for organisations such as local authorities, NHS, police, etc. And legitimate interests. While this is most commonly used in marketing, there are other uses, and an additional assessment must be done in order to determine whose legitimate interest. Is it the company? Is it the individual? Is the legitimate interest justified? Now we're going to talk about marketing and consent. This establishes a very high standard and a lawful basis as the lawful basis for processing. Control of access to personal data firmly sits with the individual. Clients must opt in. There must be no pre-populated or assumed consent. It must be explicit consent from the potential prospect. You cannot have blanket consent. It must be granular or for specific operations. You must offer the right to withdraw consent. There must be a link to your privacy policy at each collection point, and customers can remove consent at any time. Marketing and legitimate interest. Legitimate interest has additional sets of assessment. But if you have a current client, you are entitled to contact them through marketing because there is a legitimate interest, because they will have a vested interest in your business. If somebody is proceeding through the bid process with you, They may also have an interest in knowing more about you, so receiving your blogs, your marketing content. Also, there may be situations within marketing and more generically in your business where you can show a clear, legitimate reason that has no other lawful basis. The other thing to note when we're talking about global data protection, legitimate interest varies from country to country, even within the EU, which sort of delivered GDPR. And legitimate interest must be lawful and it must be ethical. Here I've put some information about consent in practice for your email marketing. And when you have a sign-up form like this, perhaps on your website, you really need to make sure that somebody has a checkbox, that there's a name and an email address. Make some sort of statement that says what the data is being collected for, and ensure that there's the link to the privacy policy. What is a cookie? A cookie is a small text file that identifies your computer to a network. Cookies will improve the browsing experience. Cookies will personalize your experience of the web. They will track your behavior online. And you do need to be careful because in some instances, cookies can be malicious. And I'm not suggesting that anyone on this call will be sort of setting that up, but that's awareness on a broader level. The granular consent is required in line with GDPR. And cookies must only activate after consent is granted. So when you set up your cookie banner on your website, you need to ensure that you're using the right type of cookie plugin which will control that. These are the images of two different types of cookie banner. This bottom one here is not compliant. The only option that your visitor to your website has is to accept the cookies or to read more about cookies. They don't have the option to reject cookies. This top one here, this one here is compliant. It allows the individual visiting your website to see the details of the cookies, to select whether they want to be targeted for marketing, statistical analysis, and any preferential cookies that are going on in the background. Necessary cookies must run on every website because they are safe and essential to the effective running of a website. So we're going to talk now about mapping the data processes. So when we're mapping the data processes, it could be done like this using a mapping tool. It could be just sort of boxes on a Word document. But ideally what you're trying to understand is where the data comes into your business, what steps it goes through, and where it's ending up within your organization. Now, it sounds like that's quite a big task, and it can be, but there are benefits. First, you understand the flow of data through your business. So you can look at where can I minimize, where can I streamline something that I'm doing within my business, and where can I incorporate the elements of GDPR around minimization, around control, who's sharing the data, and those kinds of things. You can identify potential areas for automation or system integration or improvement. There is a consistency and a transparency then in the way you do things, and that then speaks to the principles of GDPR. Also, by doing this, and I've done this exercise with a couple of people and in my previous life, and once you start mapping data processes, you can remove redundant software or process steps that are no longer needed. So there may be some cost savings in the longer term from doing that. Also, by mapping your data processes, you have information at hand which will support your bids, your tenders, because you can easily answer some of those really difficult questions that they can ask about how you do things, why you do things, and when you do things in tenders. Roles and responsibilities. Within GDPR, there are 3 specific roles named. One is the data controller. Normally, this will be the lead organization. They determine the purpose and the means of processing the data. However, if you're using cloud software, you really need to check the terms and conditions of their agreement with you, because in some cases, cloud software retains the controller rights and you are the processor, but you do need to understand that, because there has implications for how you manage it and what you put in your privacy policy. The data processor manages the data on behalf of the data controller. They don't make any decisions, they just effectively do what you tell them to do. And then the data protection officer. This was a new role that was enshrined in GDPR, and it has a specific level of responsibility within an organization. Not every organization has to have one, and a lot of organizations that are smaller outsource those services. However, if you're a public authority, local council, NHS, that kind of stuff, you must have a DPO, and organizations like that usually have a full flight compliance team. If you're doing large-scale systematic online tracking of behavior, such as an organization that's doing a lot of market research, or you are somebody like Google, where you're tracking what they're doing and where they're going on the internet. If you're doing large-scale processing of special categories of data, so if you are a health and wellness organization, or if you are working, for example, as a mental health charity where you're servicing the needs of people with mental health issues, you might need to do that. And the DPO must be a senior person or considered to be a senior person, and they report to the senior team. In many organizations, they will report to the CEO, the chief technology officer, or something like that. As part of GDPR and running a business, you will have suppliers, you may have subcontractors. And in order for you to show that you are talking about data security, data management processes, you need to look at how you're evaluating suppliers, and particularly if you are going into a bid or a tender process with a local authority or something like that. Within the bid, you will have to demonstrate what your processes are. So here I've just put some tips for you. You need to be looking at whether there's professional indemnity insurance, employers insurance, public or product liability. Is there directors and officers? What are their policies? Do they have documented processes? Are they working to governance frameworks? Are they doing staff training? In particular, are they training their staff in GDPR awareness? When you're talking about processing, you want to be looking at what are their data protection policies, what are their processes, and what are their business management frameworks. So while you're looking at this for yourself, but you're also looking at this from a supplier perspective. And the tighter your suppliers are, the more likely they are to protect any of your personal data that you might be sharing with them. And then when it comes to the technical evaluation, what are their technical management processes? For example, do they have roles and responsibilities, view, read only? Are they using firewalls? Are they using appropriate malware and antivirus? If you're sharing data with them, and you need to ensure that what they're doing at least matches the protections that you're putting in place. Because ultimately, if there's a data incident or a data breach with your supplier, it might be you who has to have the conversation with the ICO. It might be you who has to go to your customers to tell them that there's been a breach of their personal data. Talking about data security, some of them that I've already mentioned, but you need to have some due diligence on your tech systems. And what I mean by that is, before you sign up for that new piece of software, make sure you've read the privacy policy. Make sure that the tech system can deliver different levels of access, read, view, roles, manager, administrator, all of these things to protect the personal data that you might be storing within them. Look for one that gives you multi-factor authentication. It might be a bit of a pain to have to multi-factor authenticate to get into every system, but this has been proven to make it more difficult for a breach of data. Strong word, passwords, and consider using a password manager, something like LastPass, Dashlane, 1Password. They'll help you to create strong passwords. And if, like me, you can't remember all of the passwords that you've got for various different pieces of software, then your bank and your building society and your mortgage and all of those things, storing them securely with password manager with multi-factor authentication just gives you that a little bit extra protection and helps you to remember them. Make sure that you use a professional backup system and process. I know there are a lot of free ones, they're quite good, but in a business context, I always maintain that you should have a professional paid for backup. Personally, I have a managed IT provider. I'm a sole operator, but I think that's an investment that is well worth making, and my backup is provided through them. Exercise caution and school your staff on exercising caution on working with in public areas. People can look over your shoulder. People can take photographs on their iPhone or their Android phone over your shoulder without you even realizing. Think about, if you're working in a public area, what's the Wi-Fi like? Is it a secure Wi-Fi? If you're not sure, should you be working on personal data? The answer is no. You could be working on writing a brochure or doing something like that, but not accessing the CRM perhaps. And this is one that very few people, I find, think about. You get your broadband, BT, Virgin, Sky, whoever it is, they send you a router, they give you instructions on how to plug it in, but they never ever tell you how to change that master password on your home router. And that is a very basic task that you can do, particularly now when maybe we're working a little more flexibly. But that default password needs to be changed to something tighter that just you and relevant people within your household know. So what happens when it all goes wrong? Do we have to speak to the ICO? How do we speak to the ICO? What are we doing? Well, the first thing is not to panic, right? You need to understand the type of data loss. Is it confidentiality? Is it integrity? Is it availability? Have there been any risks to the rights of individuals? Is it what type of data? What level of risk from that type of data? How long has the breach been happening? Is it just, you know, something's gone wrong? I've dropped my USB on the bus. I've left my laptop. Or is it, you know, like one of these very big breaches that we've all heard about, British Airways, where somebody was accessing credit card information for a considerable period of time and selling that information on the dark web. There's a whole shade and light in between those two very extreme sort of positions. Also, you need to think about an incident, for example, which is one of the most common, which is that I reply all and I send a message to 10 people who were included on the email, and perhaps I've sent something a little bit sensitive. The question there is it a breach? Is it an incident? Depends on the content. It could just be that you've made an embarrassing comment. It could be that you shared something inappropriately, like, I don't know, a business proposal or something. It doesn't necessarily make it a reportable breach. If you do, after investigating all of that, think I do need to report this to the ICO, you've got a 72-hour deadline, and that's 72 hours tops. So if something, and that's from the point that you find the breach. So what that does is that allows you to start to understand the significance of the breach. And it may be that what you do is, in very shortly after finding out that you've had an incident or a breach, excuse me, you report to the ICO and you say, this is what we found so far. We're still researching, but you start to work with the ICO ahead of that 72 hours deadline. You need to document any actions that you've taken and what you've clearly identified has been happening as part of this data breach. And then you need to, if you are reporting to the ICO, you need to take their advice and guidance and work with them. And they will be mainly supportive unless they find that this is a massive negligence scenario where you should have just fixed this a long time ago. The question of whether to notify the individuals is dependent on everything that you found above. Now, if the ICO tell you you've got to notify all the individuals impacted by this breach, you just do it. If you're not reporting to the ICO, then the odds are that you don't need to notify the individuals, but that's not guaranteed. It's a case-by-case basis. I mentioned in the 10-step process about managing individual rights, and there is a lot of reference about a subject access right, and every single one of us have the right to ask any organization that collects and processes our personal data to have access to that personal data. And that is the right to be informed. Sorry, that's the right of access. The right to be informed is the privacy policy, the privacy notice. And a lot of people, I find, will buy a privacy policy off the internet, but it doesn't actually describe what their business does. So it's not telling the individual, well, we collect your data and we use it in this way and we store it here and we share it here. So that you need to be really clear on your privacy policy. The right of access, the subject access request. So if I raise a subject access request and I get all my data, I then have the right to go back to you and say, this is incomplete or it's incorrect data. You need to put this right, and here's what you need to put it right. You're obliged to do that. I can also come to you and I can say, well, actually, this data that you've got on me is not right. I want it to be deleted. Now, you can do that, excluding any data that you are obliged to keep by another piece of legislation. So, for example, if you are retaining data about me that relates to something regarding PAYE or my national insurance or any of those things, the Finance Act says that you have to retain that for a set period. So within that set period, you can't delete that data. So you can come back to me and you can say, we can delete this, this, and this, but we are legally obliged to retain this until this date, and then we will delete it. Okay. An individual can come back to you and they can restrict processing, so they can stop you using the data. And one of the situations that might occur is if you're in litigation with an individual over something and there's a long court case to go ahead, then they might tell you that they want you to stop using their data until such time as the legal proceedings have come to an end. Individuals have the right to data portability, and they can expect that you can extract all the data that you have on them, and you can deliver it without restriction in a format that can be used by the new system. So that could be exporting to CSVs, it could be exporting to machine language that another IT system can just import and understand. They have the right to object. They can prevent you using their data for any form of analysis or direct marketing. And everybody has the right related to automated decision making. So if you're an organisation, and a prime example is something like Tesco Club Card, where you are profiled via AI and automation based on every time you tap your club card on the reader, and you link that to the shopping you've just done, it profiles the type of shopping that you're purchasing. Now, the benefits that somewhere like Tesco's or Sainsbury's with their Nectar card is that they can minimize the amount of stock because they can manage the stock levels, and they sell that as a benefit to you, the profiling element, by sending you like your discounts and all of that sort of thing on the key things that you purchase. But you need to understand that you have rights relating to that. How long should I keep data? Well, basically GDPR doesn't tell us that. What it says is that it must be for the minimum period possible. And that minimum period will depend on your business. It might depend on your sales life cycle. So for example, I worked with a client and their sales pipeline cycle was 18 months based on the time it took for the bid and the tender and various other elements within their business. So data they collected today from prospects might not actually be identified as redundant for quite some time. I've worked with other clients where the sales and the prospect process is 2 or 3 weeks before their data is redundant. In HR, there will be things like if I send CVs or if I receive CVs, How long do I keep them before they become redundant and I destroy them? What are the rules around going through a hiring process? There is a successful candidate, I retain their data as long as they become an employee. What about those that are unsuccessful? What's the retention period there? That's a different retention period again. So you need to think and understand what those retention periods look like for your organisation. You also need to understand what regulation is relevant to your business. So Companies Act, the Finance Act, are there any specific regulations that are handed down by your trade bodies or a governing body if you're working in that kind of arena? And so long as you can justify the decision you've made about the data retention period and you've documented your reasons within a policy, that's fine. But you do need to understand that data cannot be kept indefinitely just in case. It might, to coin a phrase from my father, it might come in handy. Okay, you can't do that. It's communication. So this is really important. You need to communicate your data protection processes. You need to communicate to your staff, your suppliers. You will need to communicate in bids, in tenders. They may ask for copies of policies. They might ask for information on processes and how are you doing things? How are you managing things? I worked with a client recently on Cyber Essentials as part of a bid and a tender, and it specifically asks for copies in the tender of evidence that they are meeting Cyber Essentials and they're meeting GDPR and all of these sorts of things. On your website, have you got a cookie policy? Have you got a privacy notice? Are you sharing your terms and conditions? Are you regularly reviewing and updating your privacy policy as things change in your business? Do your staff know and understand what their responsibilities are in your organisation with regard to sharing data, securing data, and the accountability that we talked about at the beginning? Active management. Are you keeping up with your data retention schedules? Are you keeping up with your staff training on generic compliance, on data protection, and those kinds of things? These are the sort of the tacit, overarching things that you need to consider when you're looking at your GDPR compliance. Okay. And that's the end of the formal presentation. I now want to just open everything up to questions and discussion. If there's anything that anybody has seen that they want clarified, or they have, or it's prompted any questions. I don't know if there was any questions came in the chat. I have seen the bottom option on quite a few websites later. Elaine, what was that one? I've seen the bottom option on quite a few websites.
The option being where you can't reject any of the cookies. I've seen that in quite a few, and it drives me nuts because I generally reject the cookies when I'm going into any website. So it really is infuriating that and that's it.
What that usually indicates is that the platform, a lot of websites can be built on a platform, for example, like Squarespace, Wix, Weebly, and they do not give you the full ability to create the correct type of cookie banner, right? I've had conversations with Squarespace on behalf of a client and outlined why their cookie banner is not right. And I can only do kind of so much. What will happen is eventually somebody will get caught out and they will move away on the platform from the platform, or there will be some sort of issue. Also, you've got the question that a number of these platforms that are non-hard coded, non-WordPress are not UK EU platforms, and they work to the legislation in 9 times out of 10 the states, and it is slightly different there. Some of the companies that are US based are understanding, and they're making real strides in understanding GDPR. But again, we still have some, and there is a long way to go with it. You know, GDPR is going to be here forever, and countries all over the world are basing their data protection regulation on it. And therefore, the more that countries that do that, the more chase there is, things will change over time. Okay, does that help?
It does, yeah. No, it's just when you said it today, I thought, God, I've seen so many of these things, and it's you know, it's annoying because obviously you were storing an awful lot of cookies then on your browser and on your device, and unless you're, I suppose, regularly using malbytes to kind of get rid of stuff, it can be a problem.
I mean, one of the things, I have a client who's a bit, to put it mildly, bloody minded, and every time they come to a website with the incorrect cookie notice, they send an email to the owner of the website and say, you know, your cookie policy is not compliant. I was interested in using your services, but as you can't be bothered with compliance, I'm not interested in working with you. And he's very direct like that. I mean, I don't necessarily advocate that that's an approach, because you may want to feel differently, but that's his approach, and it's not for me to, you know, advise any differently. Do the data protection regulations apply to living people only? Yes, absolutely, David. Sadly, when you are dead, all your protection for your personal data is no longer relevant or valid. I had a prospect conversation going back about 18 months with somebody who worked in wellness, and we were talking about data protection and what she needed to do, and then we started to talk about working together, and she said, do you know what, she said, I've just realized I don't need to worry about data protection at all. And I went, sorry? And she said, well, all of the clients that I work with are terminally ill, and I only ever work with them for a few weeks, maybe 2 or 3 months, and then they die, so it just doesn't matter then, does it? And it's quite a you've got nowhere to go then, because you just don't know what to say. But yeah, that is the situation. Any other questions? In terms of the recording, Sochi, I believe that Branduin put the recording on YouTube where it's accessible to everybody. I know that previous talks I've done, they've been recorded and they're up there. Would families not have rights to protect a loved one's data? So Elaine, if you want to protect the rights of loved ones, you could be looking at their things like power of attorney, lasting power of attorney, so that you're taking over the right and control of somebody who becomes incapacitated as they age. Certainly as a parent, I control the data protection rights for my children. However, if a child is over 13, they can exercise their own rights. And a child that is younger than 13, if they know and understand enough, they can exercise their own rights with the support of an adult. But there is, I haven't covered it in this talk, but there is a requirement that if you are working with children, that you should have a privacy notice that is understandable for children. So if your services are targeting children, then you need to make sure that your privacy policy is understandable. So whereas if you buy on the internet one of these really nice legal privacy policies, that may well be not understandable to a child. Even a teenager might feel overwhelmed by that language. And it's really, really important when we think about writing our privacy notice that we think of transparency, we think about the language we use, and we minimize the use of complex language, difficult words, because your privacy policy is going to be read by a wide audience, and you don't know, on your website, you don't know who's going there. Is it a child? Is it an adult with learning difficulties? Is it, you know, in terms of what David is saying, being a funeral director, if somebody is, you know, grieving, they've just lost a member of their family, the last thing they want to be faced with is complex language that may feel very overwhelming, even to the most intelligent of person. If you've just lost, you know, a close relative, or God forbid a child or a parent, it's easy to feel overwhelmed by everything. So part of transparency is making that understood. Does that help? And yeah. Okay, and we are also working with Farmers Connect from instructors too, where regs apply. Yeah, that makes sense, David.
Joe, can I just ask a question on
Feel free, please.
Right at the start, you mentioned about the privacy communications, both UK and EU.
Yeah.
Under the EU ones, do they differ country to country, or is it a generalisation across EU countries?
So GDPR is an EU regulation, and what happened was that the regulation was created at this level, and then when individual countries took it on, they could apply that into their country and combine it with their own legislation. So, for example, GDPR came to the UK and became the Data Protection Act, or it was incorporated into the, and we have some elements in the Data Protection Act that is not, or even pre-Brexit, was not in the French version of GDPR and not in the German. So there are slight tweaks. For example, things like legitimate interest, there is slight differences between countries there, but the key fundamental principles are the same across the board.
Right, okay.
I mean, if you've got specific examples, you can drop me an email. I've got a reference, sort of manual, as it were, where I can say to you, like, in the UK it's this, in France it's that, or Italy it's that, but off the top of my head I can't exactly say which bits where, as it were.
Well, my only reason for that question, Joe, was that as part of our business we organise repatriations. Yeah. And I know we're talking about deceased people, however, we might also be collecting data of a next of kin or something like that. So it was just whether it varied from country to country, because one day we might repatriate somebody back to Italy, the next day it might be back to Ireland or somewhere like that.
Yeah, yeah, I totally understand that. I mean, generally speaking, there won't be significant differences that would make you think, oh, I've got to do this extra form or this extra this to go to Italy versus Ireland, right? you know, and having gone through a repatriation process myself to Italy, I know exactly what you're talking about. There are those additional things, but from a GDPR perspective, generically, no, not a problem.
Okay,
Yeah.
that's good. Thank you.
All right. Anybody else with any questions? Thank you. That was really, really lovely. Sarah, are you there? Okay, I'll just run through these last bits. I don't know quite where Sarah is, but as part of this digital skills and program through Branduin, you have access to 3 hours of confidential one-to-one support. You can have one of those sessions with me. You can have one of those sessions with any of the other providers within that are delivering in the program, and I'll run through that in a moment. And yeah, they're usually done in hour-long slots, or you could use the 3 hours in one slot if you wanted specific help or to run an audit or something with me. So always ways to kind of work together through this program. This is the program schedule. Obviously some of these have now taken place, but there's the email marketing one and GDPR that I've just covered. 12th of July is the next one, and that's on digital business tools and CRM systems. And the one-to-one business advice sessions, they can be booked all the way through July, and not just with myself, but with any of those other providers there as well. So if you've attended any of the other workshops, you may want to have this hour-long session with any of those guys there. What I would suggest that you do is that you contact Branduin and book that session, or come to me direct and I'll make sure that you get that session booked through Branduin. And there you go. That's just telling you who's sponsoring the program. It's Watford Borough Council. And that's it. So thank you so much for your time and attention and for being here today. It's been lovely to talk to you all, and feel free to, you know, book your hour slot or come back to me, drop me an email if you've got any more questions. I'm always happy to answer. All right, guys. Take care. Bye.
Thank you for having me.